Hello, my name is Hae-Sun Kim, advisor of Gangnam Labor Law Firm. Today with Labor Attorney Jung Bong-soo, we will cover the subject regarding unfair dismissal. Especially during this time, there are many unfair dismissal cases, especially regarding the foreigners who are working in Korea. So, can you explain the cases that you have covered recently, please?
Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Today, I'd like to show recent cases that I represent. This is not termination case, but I supported my client to deal with the labor issue. They may be dismissed, they assign me for sending the official email to their headquarters. So the cases, there are two cases I represented. One case is one Singaporean company. So they had about less than 10 workers working in Korea. So one of the staff who joined this company about 3 years ago. So her attitude was not accepted well. Also, because of that, the junior employee who is older than this newly hired the manager, so I think the junior worker like shouted and also kind of harassed the senior younger manager. So then younger manager complained to the branch manager, also HR team. Then they reviewed this case and they found out. So it was workplace harassment. So the harasser, the junior, the senior employee, like old employer, apologized to this newly hired manager. So then this case was solved well. Then 1 year later, company evaluated this newly hired manager for her performance. Then they thought her performance was very not good, so they put on the pre-PIP evaluation. So PIP means personal improvement plan. So then they gave this female manager a lot of work. This work is the amount they could finish it within 1 year, but they asked this employee to handle this work within 3 months. So it was too much. So she could not meet their requirement. So she was evaluated very lowly. So because of that, a company warned her to take new PIP. So if employee cannot meet some target, handling some assigned duties during the PIP period, then company may fire this employee. So company asked this junior manager to sign about this agreement, but she rejected. They may dismiss this employee if she signed. So she rejected, and she visited this labor firm, asked for some support. Then I, on behalf of this employee, I sent the official letter to their managers. So what I said in the email was that the Korean labor law is different from common law legal system in their country like Singapore. So without justified reason, company cannot fire the employee. Also, the way they treated her on the pre-PIP the period, it was long because it was planned to improve their work skill, but using PIP name, they charged more work to this female, this manager. So she could not meet their requirements. So they are threatened that they are going to fire this employee if this manager cannot complete the assigned project. So I think this employee visited my labor law firm for remedy or some consultation. So I told her, you have to protect by yourself by maybe sending official letter from labor attorney. So that is, so she asked me for legal representation. So I sent the email with some statement. So your Singaporean law is a common law legal system, so it is completely different from our continental legal system. So in case of termination, the common law legal system is very easy to fire. However, some continental legal system is very difficult to fire. So if a company decide to force her to take this PIP evaluation again, that I'll take it as a serious violation of current labor law, because without their right intention they harassed her. Also, that is a way to force her to accept resignation. So I sent official letter to their management. So I think because of my letter, official letter, company didn't react to this employee. So now employee is very happy to get some support from labor attorney like me. That is the first case. The second case is this is the Indian company. So they hired the female software engineer. So they used this engineer for 3 years. So contract has been renewed every year. So in June, they renewed the 1 year contract again with this employee. But by this month is December, so they inform her the last day of working in the company because their project was completed by the customer company. However, in Korea there are 2 more such a project being implemented by their workers. So I think company before they are firing the employee who working in this project will be abolished, also terminated. So in such a case, company should reassign, also like have the employee work in other part. That is way to avoid the dismissal. But company, without considering her position, just they informed the termination notice for this employee who work in a certain project. So I'm going to explain the company that will be unfair treatment or unfair dismissal. If company go ahead with such a plan, as a labor attorney, I'll take it to the labor commission. So this is what I explained. Then I'm sure they'll change their mind. So common legal system, common law legal system, usually they can fire people easily, but under continental legal system, it's very hard to fire people. Without justifiable reason, company cannot fire their workers. Yeah.
I see. And based on listening to those 2 cases, this unfair dismissal, I mean, foreigners who face this kind of unfair dismissal situation, they don't know where to go. But especially Gangnam labor law firm has been dealing with many victim foreigners. I think they will feel comfortable in consulting with especially like Dr. Bong-soo Jung.
Yeah. Thank you for that. Yeah, definitely. This is my job. I have represented more than 100 cases so far. So yeah, so nowadays I try to support my client in before they are fired. So it's easy to persuade the employer rather than like after they are fired. So I'm definitely sure this preventive legal representation is very important to prevent any further legal cases. Yeah.
And the good timing for the victim employee to foreigners to come to the labor law firm is before signing any document. Is that right?
Say again.
So the right timing to consult with labor attorney is come to visit the labor law firm before signing any document.
If they are fired, it's not possible to. Then there will be more difficult, very hard to deal with because lost income, also no job. It's a very difficult time. However, before they are fired, just they are informed of termination. That is time to represent my client in dealing with the company's very aggressive the decision. Then my role is to make them cancel their own wrong decision.
I hope that both cases come up with a good result. Thank you very much.
I hope so. Thank you for watching. Okay, bye bye.